Morning and good afternoon to everyone who has joined us today from Middle East, Africa, and beyond. I'm Richard Chaudhary, representing Events for Sure and General Counsel 360, and it's my pleasure to welcome you all to today's virtual roundtable discussion on due diligence framework in high-risk regions. Today's session will bring together leading legal, compliance, and risk professionals to discuss how organizations can build strong due diligence framework in high-risk MEA regions. Now, I'd like to invite our moderator, Mr. Mohammad Zakir, to introduce himself and lead the discussion from here. Over to you, Mohammad.
Thank you very much. Good day for all time zones, whether is good morning or good afternoon or good evening. And the main point is I'm wishing you a day full of prosperity and success to all our esteemed guests joining us from around the world. Welcome to the GC360 virtual roundtable with the title Due Diligence Frameworks in High-Risk Regions. My name is Ahmed Zaki, and I'm leading the legal department in Al-Hamra Group. I'm a major real estate developer in Ras Al Khaimah, the UAE, and it is my pleasure to be your moderator today. I'm honored to be joined by an exceptional panel of 7 cross-sector leaders who navigate these complexities daily. Joining me today, Ms. Saloni Tuteja, Surabhi Singhi, Yasmeen Elkenawy, who will join us a little bit later, and Ahmed, Nagy, Ghassan, Haddad, Halil, Kardicali, and Mohammad, Noor. I would have the pleasure to let them introduce themselves also. So please, Saloni, would you please start?
Thanks, Ahmed. First of all, thank you so much for voluntarily accepting to be our moderator. It's such a pleasure to always be a part of a session like this. For everyone, my name is Saloni Tuteja. I'm head of legal and compliance for a pharma company called Surabhi. We're not as rich as real estate, a company like Ahmed's. But having said that, I'm an Indian qualified lawyer. I've done my master's or LLM from UC Berkeley, specialized in corporate law. Then I have another master's in anti-corruption and compliance, as well as diplomacy from United Nations. I'm based in Dubai, and the region I cover is Middle East. So my focus will be more on Middle East, unfortunately not so much on Africa. Having said that, I'm really excited to be a part of the panel and look forward to learning from all the empaneled and the learned people here. Thanks, Ahmed.
Thank you, Saloni. Ms. Surabhi, please.
Thank you so much, Ahmed. It's really an esteemed privilege to be a panelist with everyone here. I'm Surabhi Singhi, a corporate partner at Bird & Bird in their UAE office. My role at Bird & Bird is where I advise clients on cross-border transactions, regulatory compliance, and risk management across the Middle East. Now, over my 12 years that I've been in the UAE, I've worked with many multinational corporations, private equity funds, and regional businesses who've been navigating complexities of operating in high-risk jurisdictions. Again, my focus, like Saloni, will be largely on the MEA region, Gulf, and the wider MEA region. In my view, I think today's discussion could be more timely. We're seeing unprecedented investment flows into the emerging markets, driven by various, new trade corridors or agreements and diversification strategies, and other, national transformation programs, like, for example, the Saudi Vision 2030 or UAE's vision in terms of economic diversification. So there are just so many opportunities now, but I think, as all of us know, with opportunity comes risk. So I think today the focus of this session will be on sharing, practical and implementable guidance, again, from certain real-world experiences that I've seen with various clients who've either contractually protected themselves or have kind of been caught off guard. So both sides. And I'm really looking forward to the robust discussion today and hearing the other panelists, as well as, questions from our esteemed guests as well. Thank you.
Thank you. Thank you, Surabhi. Ahmed, Nagy.
Well, thank you, and good morning, good afternoon for everyone. I'll introduce myself as corporate commercial and technology lawyer. I'm actually 15 plus years of experience within the financial and banking sectors. I'm also a qualified lead auditor in the quality management system, certified by RQI in the UK. I'm pleased to be with the other panelists as well as the esteemed guests for today's session. I hope that we'll get a best outcome and knowledge sharing out of it. Thank you so much.
Thank you, Ahmed. And Ghassan Haddad.
Thanks, Ahmed. Thanks a lot for moderating the session today morning. Thanks. Hi, everyone. My name is Ghassan Haddad. I'm General Counsel and Company Secretary in CAFU. I don't know if some of you use our product, so we're the region first on-demand fuel delivery service and car-related services as well. So you can relax at home, order fuel, batteries, oil, tire, etc. Will come your way and will fulfill the orders. With this, there's a lot of compliance to abide by, and I'm looking forward for this discussion. And my input would be really from my position as a tech lawyer and what we look at in a tech logistic company.
Thank you, Ahmed. And we hope you are all right to deliver this session fast and safe. Inshallah, to help us that. And Mr. Halil Kardicali.
Hello, everyone. Thank you very much, Ahmed, and hello to my fellow panelists and joiners. And so, my name is Halil Kardicali. I define myself as an international business lawyer. I have worked in more than 20 years in different jurisdictions, both in-house but also on law officer side, and worked on different deals and transactions across the region. Currently, I am the regional general counsel for 3M, and I look after the emerging markets region, which comprises Middle East and Africa, but also has Turkey and East Europe, so some parts of Asia, so a big region. As an international conglomerate, I'm representing 3M, so I would like to bring some perspective from specifically distribution management, relationship with distributors, which is kind of our model, and very happy to be here.
Thank you, Ali. And finally, and not the least, Mr. Mohammad Noor.
Thank you, Ahmed, and thank you to the panelists. So I go by Mohammad Noor Nabi. I'm the Group Risk and Compliance Manager for Al Masood, a company based in Abu Dhabi. It's basically a conglomerate. I think audience as well as the panelists might know the exclusive distributors for Nissan, Infiniti, Renault, as well as we have other businesses that includes manufacturing, property, and so on. And yeah, I'm really happy to be here on today's exciting topic. And honestly, I think engaging with my work, I've worked across with high-risk regions that has taught me like due diligence is just not exactly ticking the boxes, but it's more of like understanding the context by spotting patterns and whether you ask the right questions early. Quite fancy about automations and digital too. I've quietly employed that on my day-to-day operations with my team to make our processes more efficient and scalable. But at the end of the day, combining data and judgment, they're both is where experience should really count on. So yeah, looking forward, Ahmed, and I hope it's a topic I deal with on a day-to-day basis. So keen to share and as well as learn from the perspectives of audience as well as panelists.
Thank you, Mohammed. Thank you. So the reality of operating in high-risk jurisdictions across the Middle East and Africa is that it demands vigilance. We face unique challenges from opaque ownership, ownership structures, to fast-evolving enforcement regimes and sometimes politically exposed partners. A sharp due diligence framework isn't just best practice or a point anymore. I think it is more essential to prevent, it is essential more to prevent regulatory exposure or financial penalties and, of course, reputational damage. So over the next 2 hours, we will be diving deep into 3 critical challenges for legal and compliance leaders. The first one would be identifying hidden risk in the Middle East and Africa, most challenging markets. The second one will be building and documenting a scalable due diligence framework. And the third and final challenges that we are going through would be would be making due diligence actionable in contracts, monitoring, and offboarding. So welcome to all our distinguished panelists and our distinguished guests. And let's get straight to the discussion. I will start with you, Mohammad. Let's start by grounding this in data. The challenge number 1, identifying hidden risk in high-risk regions.
Sure.
What are the non-negotiable data sources or innovative tools you can rely on to detect hidden risks early in high-risk environments?
Thank you, Ahmed. That was a great question. And honestly, when you're working in with high-risk regions, you've got to be really deliberate about what you rely on, because the usual stuff may not always give you a fuller picture. So for me, the basic that are still non-negotiable are items like sanction databases. You have your PEPs screening, you have your ultimate beneficiary ownership details. Now, that's the foundation, right? So you need that layer in place no matter what. But this is where it gets quite interesting. In high-risk environments or jurisdictions, that's just like a starting point. So what I've learned during my course of exercise is that that real red flags, they don't often show in structured data. Like you won't find them in a spreadsheet or you won't find them in database fields. They might show up in the noise, or like local media, or as well as language-specific sources, or even small, quiet changes that systems quite often could miss. Things like sudden shift in the ownership, or maybe say a new board member who has been appointed, or who that board member who was appointed might have a political relationship that aren't immediately obvious. So that's where I think you need to go deeper. Now at Masood, we also rely on adverse media screening, basically not just in English, but also we search data with multiple sources. And if something like new regulatory filing or maybe a name pops up in local news outlets, we get to review it in time. So as I was speaking, Ahmed, about automations, we've also built up a SharePoint-based portal that does the due diligence at the back end with the plug of API. So basically, it does your screening for regards to with the Emirates ID, or as well as company documentations. It goes through the screening of the UBOs and all of that. So if there is a hit from the tool, it does escalate to risk and compliance team. That's where we sit, and then the human layer kicks in, where we do the required standard or the enhanced due diligence. Now, with regards to the tool, Ahmed and the panel, I'll be honest that tools are great. They are, but they're only good as the question that you just asked. Experience does play a massive role, and over time you get to notice patterns like gaps in communication, or inconsistent ownership, or even silence where there should be noise. That's when you get to know that something is off. So in summary, like structured data maybe gives you the map, but unstructured signals, that's like combined with experience as well as gut instinct, that's what helps you navigate the terrain. Okay, that's where I think the real due diligence begins.
This is comprehensive, actually, Mohammad. I thank you very much for that. Surabhi, would you please, what Mohammad said takes us straight to the ground level in the GCC also. So what are the top 2 or 3 country-specific compliance red flags a global team must highlight when looking at the UAE and KSA? What would you advise your client to do?
Sure. Thanks, Ahmed. I think there are just so many, like as you rightly said, applying a generic risk framework or looking at generic, let's say, red flag tick box exercises these days is no longer sufficient. Nice. It really needs to be tailored to the jurisdiction, see what each jurisdiction kind of offers. Otherwise, there could be significant, regulatory as well as reputational risk as well, right? Sometimes. Now, from a UAE perspective, as most of us here would know, there are about 40 plus free zones here, and they're just distinct licensing regimes and unique compliance risk, which each free zone or mainland, will each of them have their own separate compliance frameworks. The key aspect here is, the risk of free zone versus mainland licensing mismatches. So, for example, we've seen so many clients come to us saying, oh, we are going to enter into an agreement with this company who's based in Ras Al Khaimah to provide some software services in Dubai, right? And, it just kind of doesn't work. You need to see what the company, you're contracting with, where are they based? Are they licensed to do what they are doing? Because that's a big red flag in terms of, your due diligence exercise on counterparties. If they're not properly licensed, if things go sour, that could, even be unenforceable in UAE courts, because the counterparty was not even licensed to provide that service that you wanted to get from them. So, I think that's one of the very key big due diligences exercise as a global client that needs to be undertaken with a counterparty from a UAE perspective. The other aspect I would say from a UAE point of view is also the UBO opacity, right? While UAE has now strengthened its UBO declarations, we're seeing as part of the setup or as part of annual compliance, free zones, mainland, the authorities, the registrars, they're all requesting for UBO declarations. But we can still see some free zones have a more relaxed approach, I could say, if I may use that word, where, they're trying to offer complete confidentiality for the client. But what happens is they are still creating, layers in terms of their structure that could obscure a beneficial ownership declaration. So I think as part of, an exercise of due diligence, the global company should not just accept that, yes, we filed with the registrar or we filed with the DED here and they've said it's sufficient, because more often than not, that's not the gold standard, right? So you need to have your own requirements in terms of what do we need as a global organization from a UBO perspective. Like Mohammad said, we need to kind of make sure that there's no PEP, there's no sanction person. So I think that kind of needs to be your internal requirements that need to kind of override versus just a declaration saying, oh yeah, we filed this with the registrar and they've been happy with it, or we filed with this, this authority has said, yes, this is fine. So I think from a UAE perspective, I would say these two are two critical things in my view that one should look at as a corporate lawyer. Those two main points would come to my mind. From a KSA perspective, I would say the well-known kafala system or hidden sponsorship, arrangements with Saudi nationals. Now, while, despite the Vision 2030, where, many 100% foreign ownership sectors have opened up in Saudi, we still see that there are some form of, agreements, even I wouldn't call it nominee agreements, but some form of arrangements with Saudi partners still exist. So it is important to see, what those arrangements are, because what you don't want is there could be some Saudi national who has some, let's say a PEP connection, and any payments being made to them, shouldn't look like creating any corruption or sanction risk, etc. So I think it's really important to review any sponsorship or any, let's say, such arrangements with your Saudi partners. The other thing from Saudi is, I would say, is your Saudiization compliance. Now, an immediate question I get asked is, why is that relevant for us? Why should we see what our counterparty's compliance with Saudiization is? I think what happens is, more often than not, typically global companies would enter into agreements with Saudi companies because they're looking at government contracts. Right now, government contracts require them to have, the company should have a green status, which is when you've, complied with all your Saudiization requirements. Now, if you're non-compliant, then in that case, you could be under let's say a red or a yellow status. But then what that means for the global company is that you could lose out on your government contracts, the very reason why you went to a local party. right? So therefore, it is important that you look at these kind of compliances, where they stand and whether they've ticked those boxes or not. So it's really, in short, very important to see what the distinct regulatory environment in the country is and not just rely on generic due diligence questions. I think the key is, what questions to ask and what documents to verify, because every jurisdiction has its own realm of, risks and what needs to be looked at.
Wonderful. Thank you very much, Surabhi. If I'm moving to Ghassan now, would you, in your point of view, in your opinion, if I'm going to ask you to give us the same question, actually, the top country-specific compliance red flags that you have met in your practical life, in your company, with lot of compliance around your business, what would you say?
See, Ahmed, I think Surabhi tackled most of them, but I'll add to what she said, and then I'll add one or two red flags in my view. So on the licensing, spot on, like people or companies tend to forget that not like having one license is not enough in the UAE. Us as a logistic tech company with transport of fuel, we have to have different licenses in each and every Emirates and free zone. And I mean, for instance, we have in all the Emirates except Abu Dhabi, because it has its own special rules, and we're not able yet to expand to Abu Dhabi with the fuel delivery services, right? Another thing on the UBO, and I think this touched between Mohammad and Surabhi, both of them talked about the UBO red flags. What we face sometimes, and notably in our expansion to few markets, is the non-online presence of the UBO in question, and then we hire special investigation, and that's more worrying for us, because an online present UBO is someone that you can trace, that you can make your mind about, but someone with zero online presence is someone really to watch out for, and we hire consultancy companies that go a deep web search, etc., in order to know really who's our counterpart, right? The other red flag, I think, again from a tech perspective, is really around data protection and localization of data, and that's very important when it comes as well to free zones versus mainland, ADGM, DIFC in the UAE versus the federal data law. The federal data law that is not enforced yet because of the committee that's not yet established, versus ADGM and DIFC that adopt a more strict rules when it comes to data movements, right? And then in the tech, we have the movement of data between where you're ordering from, where we're delivering the service, the GPS of the driver, the fuel orders, the payment credentials, etc. And those are really scattered in terms of they might be in different jurisdictions and in different localization. And it's very important to have this mapping of data and the transfer of data and make sure that's compliant with each and every jurisdiction that this data sits in. That's notably more important in the case of KSA, because they're really big on PII, which is the privately identifiable information, and that's where it becomes sticky for us as a tech platform, where we host our data and outside of the region, where we need to change our mindset, have additional costs in order to be compliant with the countries we expanded to. So those more or less, and again, when you talk fuel, you talk about a regulated market, and you talk about sanction list. So we really need to be mindful who is our counterpart in terms of supplier of fuel. That's more or less that comes to mind.
This is very important thing also. I think, thank you all, of course, and I think those insights now from Mohammad, Surabhi, and Ghassan, I think they are identifying the risk requires local knowledge and the right data before proceeding into any business transactions with different zones, and also the market itself, and from the culture point of view of understanding business and how they deal with it is also very important, to make sure that you are aware about the culture there, so before going and proceeding. Let's pivot to challenge 2, how we formalize this process and make it defensible also. So I'm challenged to building and documenting a scalable due diligence frameworks. I would start with the Saloni. Let's look at the backbone of our operation, the framework. Sorry?
So Ahmed, maybe before I tackle the question.
I didn't
Can you
ask the
hear me?
question. I didn't ask the question.
Oh,
I thought
sorry.
someone wanted to say something. That's why I started.
I got too excited listening.
Because it's a very important subject. The framework is the backbone actually for all businesses now, and everyone should be mature enough to understand that it's not anymore. If someone wants to do business, I'm going to do this business and that's it, without framework, without policies around. This is very important. So my question is, for organization building a program from scratch, something new, what are the key components of a truly scalable due diligence framework that can flex across different Middle East and Africa jurisdictions?
Thanks, Ahmed. Finally, the question has been raised and my excitement is still there. But Ahmed, if you allow me, I would just like to add a few more dimensions to what was being raised in the earlier section, which was basically high risk and identifying high risk in high risk countries. Maybe I think in addition to all these beautiful points that my co-panelists mentioned, maybe also it's very important to add dimensions like what industry you work. And this is what Ghassan was also, kind of pointing out, because the risk parameters, your risk environment actually depends a lot on what industry you're working in. Real estate has very different risk parameters than pharma. The other thing that I would like to point out is even within the industry, what is the business model that you are adopting? Right? Are you your business model is more distributor oriented, like Halil mentioned, or it is more vendor based? And I don't want to speak for Halil or you, Ahmed, but maybe your being in real estate is more based on vendors and suppliers and things like that, which may be a lesser exposure for industry like pharma, where our risk is more on whom we interact as being as consultants, healthcare professionals, etc., etc. So I think when we identify a high-risk country, it is also important what industry you are. Again, and taking an example of pharma, because that's where I hail from, is Iraq or pharma industries may be lesser risk than ammunition and defense industry. Again, these are just presumptions. I'm sure they have their own parameters, because pharma does get a lot of, I would say, exemptions on operating or inoperating in such industry in such countries, whether sanctioned or otherwise. So I think that's another dimension that I wanted to kind of add on. Now, finally, to the question that you raised is how do we build a scalable model? And I think, or a DD framework. I think the key word for me is not DD framework, but scalable, because every company starts with that first 1 million and goes to 100 million, 1 billion, or to the size of companies like Apple. So I think scalable is the biggest, for me, the buzzword. Now, when we say a DD framework, it is, we can have a mashup of all the good points and all the good, what this should be the do's and the don'ts. But I think before we do that and create a DD framework, what is important is the goals and objectives. What are you trying to achieve by having a due diligence platform or a due diligence framework? Again, your goals and objectives, your scope will all depend on your industry, the size of your company, the countries that you are working in, and amongst many other factors, and also the history. So if you've been under an FCPA investigation or Foreign Corrupt Practices Act investigation by SEC, DOJ, of course, your DD framework will be little different than somebody which is a private limited entity. So all these factors of clear objectives and goals is very important. Then the other thing is simplicity. your DD framework should be simple, because it's not lawyers who are using the DD framework all the time. It is actually
Yes.
the business person who is raising the request. If he or she, it, they, and I don't want to compartmentalize any pronouns in today's world, but having said that, they are the one who are using it, not us. We are on the lesser and the easier spectrum, where we are actually just reviewing the request. So it should be extremely easy to understand, and also not time consuming. If so, as they say, justice delayed is justice denied, right? So if your DD process takes 5 months, 6 months, I'm sure it is not something that business will wait for. At the end of the day, we are a collaborator, we are strategic partners, but the term is strategic partners. If we are not able to contribute in strategy, sorry to say, legal and compliance has limited role in a business. And I'm talking as an in-house counsel. Of course, Surabhi, from being from a law firm, may have a different outlook as far as her role in a DD framework is concerned. So that is again very important, is ease. And then not everybody needs to be part of due diligence. Not everything has to go through due diligence. You have to create a framework. Okay, if it is somebody acting for or on behalf of my company, can. But if it's just somebody getting coffee every day, or getting coffee, things or milk to your coffee, or administrative, maybe you don't need a due diligence. So it again depends on what is the risk profile that you are creating, which again becomes a part of objective. Again, today, the other buzzword is AI. Please rely on technology, automation, because a lot of these things become a pattern. So you can identify a pattern, especially if you have a customized due diligence framework, which we obviously, all of us will be indicating towards it. It's not one size fits all. So, use technology, use automation, and also use the data that is derived from this due diligence. So if you have 1 year data of due diligence that you have done, what are the red flags that you have commonly identified, things like that. So use that. While I'm a big, supporter of technology, but however, we should not forget that people are extremely important. That is, again, ease of doing business. Not everyone needs to be involved, but at the same time, creating a RACI, that who needs to be accountable, who needs to be informed, then turnaround period, 6 months, like I said, is a very smart way of doing diligence. Again, it depends on the length and breadth of due diligence. It may be required if it's an M&A, but if it's your regular vendor or a distributor, then 6 months may not be a feasible or a very business-friendly timeline. Again, M&A can take years also. So 6 months at that time is a small speck. So then again, the other thing is proactive governance, which means you have to be very proactive, not reactive when it comes to due diligence. Due diligence itself means proactivity, not reactivity. And then learn to take feedback. If your due diligence while legal and compliance love, it's our baby, we think it's pitch perfect, but please take feedback, because we are not the users, we are just the monitors, as we call ourselves. And that goes back to, due diligence. Doing due diligence is just a start of the entire process. There's a full life circle. Due diligence is the start, and the continuous governance, monitoring, auditing, all becomes a part of a due diligence life cycle. So that's a very, of course, we all can go for hours and hours on this topic, but I think those are some key points that I think may be essential.
Amazing. Actually, Saloni, I'm totally with you. I will just mirror if I'm asked the same question. And I'm glad that you concentrated, among other things, on two things: the human side of who is going to apply these due diligence frameworks, and the second thing that emphasizes about on that we should be supporting as in-house lawyers or even law firms lawyers. They should support the business, think how to support the business. There will be always a gap between a law firm and specific industry in the meaning of practically usage of the frameworks, which should be completed, and this is okay, of course, to be completed by the in-house lawyers. He will understand what are applicable and what is not. Thank you, Saloni, for this amazing response. If I'm going to Halil, Halil, with your extensive experience, and I know it is a very well experience. What would be what we can be add to Saloni's response about the key components of a truly scalable due diligence framework? Although I know Saloni has something with scalable, but I think everything should have criteria to be used that can flex across different Middle East and Africa jurisdictions. Halil.
Thank you, Ahmed, and thank you, Saloni. So, I mean, before I go into the due diligence process, actually, the points that our colleagues brought about licenses brought back some memories. I remember when I was working on a very huge mining deal, and everybody was at that time. I was with the law offices, and everybody was very excited. Our client was really wanted to make that investment. The deal seemed huge. We set up big data rooms. We went into the data room. The first document I reviewed, they didn't have a mining license. And it was the easiest, the executive summary I ever wrote. That they don't have what they want to sell. So although it seems simple, these things pop up very regularly, actually. I mean, it really finds itself in the practice. In terms of putting down a due diligence framework, of course, I mean, the perspective I'm trying to bring is from a global conglomerate's perspective, where we have multiple. Saloni very rightfully underlined the importance of simplicity, but the stark reality is there's a lot of complexity that goes into putting down a due diligence program and making it scalable, because scalability actually needs standardization. And up to now, we've all been talking about how things are non-standard, right? So, and every country comes with its own colors, with its own complexity, and also, as Saloni has underlined, every industry also comes with its own separate needs of rules, regulations, and complexity. And in a conglomerate like 3M, where we have the industrial business, where we have the technology business, where we have the consumer business, all under one umbrella, the complexities and the people we deal with also change, of course, a lot. So how do we make it standardized, and how do we do it so that it becomes scalable in a global scale, where we don't have different due diligence checklists, one in the UAE, one in the USA, one in Belgium, and so on and so forth. And the way that my company has approached is that we have made a two-layer approach. The first one is, what does the company need to abide by from a global perspective? And from that, we of course have, I would say, FCPA, but please, that's a big bracket of multiple laws who affect, from the UK, from France. Now there are multiples that affect when you do business globally. So the Corruption Practices Acts. The other one is trade sanctions and restricted parties. This plays a big role, especially if we're trying to move along, goods across the globe within jurisdictions which are very exciting from a growth perspective, but also very risky, which comes with that. And of course, the third one being the competition laws. Once again, not necessarily completely unilateral across the globe, but has lots of underlying and common principles. So these three creates the base of our compliance programs and due diligence checklist that we don't deviate from. If we want to do business with a distributor, if they want to do business with us, this is a take it or leave it part of the deal. And then we, of course, sprinkle that with local knowledge, because if you just have the global template, that's not going to be first, it's not going to sit well with the jurisdictions that you might operate. Secondly, it's probably going to miss things. For example, going back to the license example, licenses are not as prominent as they are in the UAE and Saudi Arabia in other jurisdictions in the world. So it's not necessarily license hunting every time. So having, once again, three levers in this stage, where we have the business teams that provide local knowledge, local understanding with regards to the people that we want to deal with. Financial checks, once again, finance teams going in and doing their own financial due diligence in terms of good payments, well, in some jurisdictions easier, in some jurisdictions less easy to get those documentation, and then regulatory needs, as we have underlined, in terms of doing business the right way, licenses and so on in the jurisdiction. And from that, what we do is we do an integrity assessment. We call this the integrity assessment, and we use a lot of third parties who support this program. This is actually stored in our cloud servers, where we gather all the information from people that we want to deal with, who wants to deal with 3M, and through that we get a lot of knowledge from legal procedures that they might be into. News articles also is an important source for canvassing anything that doesn't necessarily fall under the jurisdictional umbrella, or any connections with the government, any government nexus that parties might have, which is very prominent actually in the UAE and Saudi Arabia, where the industries and the money is actually quite intertwined with the government. And what we do is we also have levels in this integrity assessment process that we have, and those levels, once again, is definitive of the details of the questions that will be asked, and the difficulty of the questionnaires that will be shared, but also it dictates the renewal period, because one also important part of doing business in high octane market is things change quite quickly. I think it was Mohammad who touched base with that. Things can change. You know, the manager can change. The director can change overnight. So in these jurisdictions where we see high risk, we also renew our integrity assessments more regularly, sometimes on a yearly basis, to be able to capture things that have changed. And of course, we in the end tie these all down with our agreements and declarations that we collect from our partners, because of course we do our jurisdiction, our due diligence. Some things come up, sometimes there are red flags. There are red flag mitigation plans that can go in. You know, we can get further declarations, but in the end, we also tie it down to our agreements, to the declaration given by our partners, so that we have, in the end, if there is a compliance risk, immediate termination rights, and we can walk away from the relationship if necessary. So, once again, in terms of scalability, we have to have lots of standardization, which is not easy, but once we have the principles, and it's easier to dance around them and put up the system.
Great, thank you very much, Halil. So in general, scalable frameworks need also defensible records. So Ahmed Nagy, would you please, from a regulator's point of view, what are the best practices when meticulously documenting the due diligence process to ensure full compliance satisfaction?
Thank you, Ahmed. And I believe that the panelists really highlighted really a very essential points about the due diligence in general. However, and even we recently noticed the update which happened on 2018 AML and anti-corruption law, which I believe the government here in the UAE is really very focused to emphasize and give more better exercises and practices when it comes to the due diligence, as well as other perspectives like the anti-money laundering, as well as the corruption, and ensuring that there is a proper and enhanced practices with a proper audit trail that are already in place. And actually, as a quick win out of the newly introduced law number 10 for 2025, which is issued, I guess, around 20 days this in October, where they have focused and gave really a huge focus with regards to the customer due diligence. And then even the obligations were tightened, and a better checklist and integrated and automated risk scoring as well. This is in addition to the great consideration of VASP, where virtual assets has been considered and included as well, to document as well not only CDD but even ECDD as well triggers. I think as well a better focus on the ultimate beneficial owner was also introduced, and really such practices and legislations introduced is intended to achieve the best due diligence as well as governance perspective and scope. When it comes as well to the financial institutions, I think there is a huge focus when it comes to the systems and trigger platform, where used by banks and financial institutions to have early triggers, additional red flags, and then ability of having a clear audit trails to be submitted to the regulators as and when required, which to state the dates, the identifying all the transactions, its amounts, the risk rating for the customers, as well as the transactions, especially the ones which are across borders. I think, and even the pre-screening that happens on the customer, which the financial institutions really play a very essential role, since now majority of the transactions and financial transactions are even through the digital channels, which holds higher risks. And as much as the sector gets developed, higher risks as well as unforeseen risks are there, which needed to be addressed as well. So a proper documentations, whether a centralized platform, tamper-proof repository provided by the organizations are already kept, and a proper monitoring and tracking of those transactions are in place and then reported regularly and proactively to the regulator.
Thank you, Ahmed. Thank you.
You're welcome.
This is very important thing, and I think documenting diligence. And if anyone else from our esteemed panelists would like to add his point of view or her point of view to this challenge number 2, building and documenting a scalable due diligence framework. Well, let's move to our final, and from my point of view, most important challenge now, which is about making this due diligence actionable throughout the third-party lifecycle. So again, Ahmed, I will start by you. Don't leave don't leave now. Let's discuss how to leverage diligence into legal authority. If our audience would only incorporate 2 essential non-negotiable clauses into a contract with a high-risk third party to truly make their pre-engagement due diligence actionable. 2 things. If you can add third one, of course, but I would like at least 2 things. What would those 2 be?
Okay, so that's actually a very interesting part, since like in principle, the contracts and the agreements between parties actually like establish the main relationship and the contractual responsibility between the parties. However, from a financial or banking perspective, and then I would suggest initially to have a proper audit rights clause. Whether to the organization or the financial institution as a bank, as well as regulatory, which is as a third party or regulator audit rights to be in place as and when required, with a proper frequency for the providing of reports, the necessary reports that are required, to enable a proper auditing from the bank on the third party or the service provider that's actually providing the services or the documentations or the outsourced activity, as well as to fully host and cooperate with the regulator as and when there is any suspicious or somehow unclear transactions from a regulator perspective, and to fully liaise with the regulator to provide the necessary and required documentations, even if the service provider or the other party is not actually based in the same country as well. And that's very essential. Secondly, I believe the part of the monitoring perspective, as well as breaching of the main compliance requirements. That's a very essential clause as well to be included in the agreement, with assurance that immediate notification to the financial institution or the financial institutions or the banking as an entity, really time of a great essence and importance to be able to mitigate the associated risks, especially when it comes to disclosures or breach, which allows as well an immediate action and reconciliations that's required, and as well adding some controls and penalties or remedy plans in such case. Third part of it is that having a proper BCP plan in place where it's already reviewed and provided to the financial institutions to ensure that business would not be interrupted at any point, and there is sufficient DR servers or plans to ensure the business continuity.
Thank you, Ahmed. Very important things. Thank you for the third one also. Especially. So,
you asked,
Surabhi,
I did.
Thank you.
You're
Surabhi, expanding on those contractual foundations that Ahmed shared with, beyond the termination rights, what specific legal clauses are absolutely recommended for effective risk-based monitoring and ongoing compliance?
Sure. I mean, I'll also probably maybe, instead of two, will maybe go on to three. I think it kind of falls within three different buckets, right? Which is very important, which is addressing at onboarding requirements, then your continuous monitoring and offboarding. I think Ahmed has already highlighted some of the monitoring and offboarding termination related aspects. So maybe I will, at the time of onboarding, some of the quite important contractual protections that you should look at is again, this will need, I just want to kind of highlight that this will really depend on the level of risk profile. So it can't be kind of standard that each contract should have these 10 representations and warranties, or these, or they should have these 10 contractual provisions. I think the first task will be to first determine what is the risk profile of your counterparty that you're looking at. And then based on the risk, you could qualify them under the basic protections and enhanced protections, and then some which would be, let's say, your high risk, where you will need a full suite of, protections in your contractual documents. So in terms of onboarding, I would say, the first thing that we need to look at is your representations and warranties. So once you've identified what kind of risks there are, it's very important to include the necessary representations and warranties in your documents. So for example, on your beneficial ownership, or with respect to sanctions or your PEP confirmations, all of that should be very adequately captured in your rep and warranties section. The other thing that should be captured is your anti-corruption compliance certification. So for some countries, you will need to have some form of certifications. So it's important you know what the local law requires and then ask for those specific representations and warranties where those laws require a company to have that anti-corruption compliance certification, for example. And the other part where, which I mentioned earlier, is your regulatory license verification. So you should have necessary protection in your contractual document to show that, yes, that the counterparty has the necessary license to do what you're agreeing to do, right? And the last one is, I also saw someone had raised that point in the chat box with respect to AML, the increased kind of AML focus of regulators. I think it's also, kind of something related to that is source of funds, which maybe we need to kind of also see. Sometimes, again, this may not be relevant for all aspects, but, source of funds where super high risk jurisdictions or high risk transactions as well, in terms of value, necessary rep and warranties for source of funds should be asked. So this will be, my kind of one clause, which I would say in terms of onboarding should be there. The other thing is, sometimes where you are not very sure, you think it's a very high risk, contract that you're taking on. It's also possible to do like a conditional contract. So where you make it conditional on, let's say, providing a sanction screening or providing, let's say, all your UBO requirement, or in terms of where, let's say, if you want to do a site visit to see where, how the company is operating. So it's completely fine, I would say, from a risk profiling perspective as well, to have these condition precedents before you go on to actually having an effective contract. So this is what I would say from an onboarding perspective. I know Ahmed has already gone into monitoring, and I think Saloni also talked about AI and technology, which we should really use as part of tools for ongoing monitoring in terms of what should be done. The only other thing from an offboarding point or a termination point is, I would add here, is I think it doesn't finish at termination. We need to kind of also think from a risk or a compliance perspective as to post-termination obligations. So for example, if, in some jurisdictions require that you need to have a record for 7 years, then those kind of obligations should be there in the contract itself, rather than relying on, statutory obligations or, let's say, good faith obligations. I think those kind of obligations, any post-termination obligations, should be included within the contract. And also, we've seen sometimes clients kind of ask for clawback provisions after the contract is, or at the time of termination. If there's some breach, or, let's say if there's been, non-disclosure of necessary PEP, UBOs, then you could have certain form of clawback provisions as well, because there could be, under your multinationals could have obligations saying that we can't make payments to these countries, or we can't make payments to sanctioned persons. So if you could have, these clawback provisions as well, that kind of helps in terms of managing your risk profile after you've found out, yes, there is an issue. So I think, these were my quick, important provisions that I think I would recommend having.
Thank you very much. Before proceeding with, I have a question for Ghassan, so I'll ask you this question, but I want to welcome Miss Yasmeen Elkenawy. She joined us now, and I know that we are going to we benefit from her extensive experience also joining us in the remaining time.
Thank you, Ahmed.
Thank you, Yasmeen, for joining. Now, Ghassan, if with your experience in your industry, which is related to many other industries actually also, can you add more legal clauses to what Surabhi said, which are recommended for effective risk-based monitoring and ongoing compliance?
Thanks, Ahmed. I think it's really always, hard to be the last to speak about the topic after two people really explored everything. But for me, from my point of view, what really worked in the onboarding part that Surabhi talked about is the supplier code of conduct to avoid back and forth with the suppliers. So all the minimum required when it comes to AML, when it comes to due diligence clauses, we plug them in the supplier code of conduct and they just sign on it the same way they would sign on term of use. And that really avoids, one, it shifts contract negotiation faster. We wouldn't include the how do you say, the common clause in the contract. We would rather just put them in supplier code of conduct that they would abide by while subscribing with us as a company, right? The second bit on the ongoing, I would say, monitoring and compliance. Well, we have a part of our business which is offline. So we always mention ad hoc inspection rights. We're client facing. So even if we're not ourselves delivering, it's a third party who's delivering on our behalf. We'd like to inspect when we want the encryptions on data, the storage facility, how they deal with their employees, because this has really direct impact on us as a tech platform. If they miss kind of, or they're not compliant, it's not us, but then the customer or the user would come to us before anyone else, right? The other thing is, and that's the model we're doing in our expansion, just to shift as well the compliance burden and to position ourselves as a tech platform, is we shift the regulatory compliance to the party. And by that, we include what Surabhi mentioned as a condition precedent. Before we enter into any contract, they need to secure all the regulatory approvals, etc., and they need to maintain them, renew them as an ongoing condition within the contract. So that's a clause that we retain in all our contracts, be it with civil defense, with energy authorities, with transport departments, because it's a multi-layered approvals. We really shift this to our partners just to make sure that our partners have the adequate expertise and business license, right? And then what would require as well is a immediate notification in case the license expired, in case there's investigations from the public authorities on their premises, etc. Just as well to manage the public policy bit of it when it comes to our offerings with our customers. So those more or less, obviously we talked about the termination disclosure clauses with Ahmed, so I have nothing to add on this point. Yeah.
I think I would go to Yasmeen with a question to relate this subject with the previous challenge with scalability. While we add clauses into our that we are discussing now, the main clauses that should be incorporated in our agreement for monitoring and ongoing compliance, but still, to how can technology enhance scalability without compromising quality in this case?
Yes, so I would say that
we are going back, but I thought this is important to relate it here. Sorry.
Yeah, it's okay. I would say that we would have at least 5 pillars in order to have a truly scalable DD framework, due diligence framework. The first thing that we should look for is the risk assessment and the tiering, like evaluating the factors of risks over there, like the country factor, the role, value, interactions with public officials, and other risks that might differ from one sector to another. The other thing would be, the second pillar would be standardizing a workflow, a due diligence workflow. As an example, you can use questionnaires, you can use acknowledgement, as Ghassan said, screening processes if you have an internal screening system, or if you have an internal due diligence team who can run enhanced due diligence in case of high-risk customers or business partners, and other enhanced procedures that would be tailored as per your risk appetite for your organization. The third pillar would be decisioning and escalations. You need to set thresholds, assign the compliance team ownerships, involve the legal team when required. Also, contractual controls. You need to ensure inclusion of necessary clauses flow down provisions. I'm sorry?
This is the point. Yes. Yes.
Yeah, so you need to ensure the inclusion of necessary clause. So in my organization, we have an entire document with all the possible clauses that you can use in your contracts. Like you can dream of any clause, you will find it in this document that we have. Anyone can use it. All the legal team has access to it. Like we have the clawbacks, we have the flow down provisions, we have the audit rights, everything, compliance clauses, everything is covered in this document. And I would highly advise that you would, in your organization, you would start having a document like this one to be like a guidance note for the legal team. And we always work on improving it. So it's not staying there forever. We're always reviewing it, we're always improving it, and we're using it most of the time in our ISO certification. Whenever we're being audited, this is the first thing that they ask about. Last pillar would be monitoring and revetting. You need to conduct, you need to look for specific triggers that you have in your sector. Like, what are the red flags in your sector? Like, I work in power sector, the triggers or the red flags that I can see in my sector is different from someone in the financial sector, per se. Each element should be tracked in your internal systems with clear ownership and like time records assigned to clear the tracking. Like we have a GRCM whenever we have any triggers or we have anything that we find in an audit report, we assign a function to start working on improving this, and then we start auditing them that they have already implemented it. So I don't know if you have it all in your organizations or not, but it's very handy to have it as well. If this answers
Let's say
your
that
question.
no comment out of confidentiality, no comment. Due diligence also. This is out of due diligence. Back to the third pillar, the document that you advised everyone to have. From your view, which one, let's say the 2 or 3 classes that you make sure that they are included in your contracts, in the sector, in the power sector?
Definitely compliance clause, audit rights.
With laws and regulations, you mean, or compliance in general?
Compliance with the with the applicable laws and regulations, and compliance with the policies that they acknowledge from our side, like the supplier code of conduct or the ethics and business code that the business partners sign on. So the supplier code of conduct is only for our suppliers. For our business partners, they have the ethics and business code of conduct. This acknowledgement is legally binding, so they have to comply with it. And also there is another clause that I always add with regards to changing of the governance or the management of the company, and another clause of disclosure in case of any conflict of interest, or if they are like being subject to any kind of investigation, sanctions, anything, they need to report it to us immediately.
Thank you, Yasmeen. Thank you. So, Mohammad, Noor, Nabi, complexity requires speed. And technology is the main supporter of speed right nowadays. So what role does technology play currently in automating the due diligence, monitoring, and alerts? And where do you see AI making the biggest difference in the next year?
Oh, this is tempting. So I'm really tempted to pass this question to Saloni as a gift, but I'll give my piece of advice. So technology, as I guess Ahmed, is already playing a big role among us. And as Saloni and Surabhi also mentioned, that also someone who loves the fusion of technology as well as work, I guess establishments should leverage AI. I mean, as mentioned initially, I think I mentioned that we use automations to handle routine stuff like screening of third parties, due diligence, sanctions lists, and trigger alerts whenever something goes on the change. And also just recently, just like Yasmeen highlighted with regards to solutions, we have inbuilt solution and built application that provides training, constant trainings on topics that cover bribery, corruption, gift entertainment, sanctions. This is connected to an assessment, which upon successful completion, the initiator or the other person gets a certificate. This again can be accessed by our compliance. This can be accessed by our employees across using their phone or the desktop. And such leverages help save a lot of time. They help reduce manual errors, and it helps my team focus on more complex stuff. Now, as I see where AI would really be stepping in, and hopefully soon is somewhere around in pattern recognition, like instead of just reacting to red flags, AI can maybe possibly help us spot early signs, things like unusual ownership changes, something around ESG violation or political shift, before they become actual problems. And something around the natural language processing, I think that, as we can see, it's improving day after day. AI can now, I think, just search local news, social media, as well as regulatory updates, even in different languages, be it. They can also help you summarize in what matters. And that would be huge for high-risk regions, especially where structured data isn't always available or not, let's say, less.
Which you assigned this question to her. So I would like to hear Saloni's point of view on this. And also other things I'm going to ask her, but let's have Saloni's point of view.
Today is my lucky day, and it's not even my birthday. So thank you for the gifts and love that is getting showered. Yeah, I totally agree. I think technology is very relevant, and let's make use of it, but obviously with a pinch of salt. While we have a lot of technology that is making the news readable, for example, I can understand English and Hindi, but I might not be able to understand Italian, for example. So I think language integration and reading is becoming very tough. But at the same time, I would also like to pinpoint is that keep your ears close to the ground. So, for example, if you're in a pharma company like I am, your medical reps are closer to the ground, or people who interact with your distributors, and I'm sure, Ahmed, you have people who have a daily interaction with vendors, and you might have limited interaction again. So I think reputation is sometimes much more, every best friend has a best friend. So reputation you can get a sense of it, keep your people closer keep your people close to why you're doing due diligence, which also goes back to or stitches back to the objective of the due diligence. And I think Sarthak, in the question in one of the chat, he had raised a question is how do you ensure that your due diligence is not at the cost of, and I'm just reframing the question, is not at the cost of your shareholder value or profitability. I think, and this is not only shareholder or profitability, it's also getting a buy-in internally. So it is all together. We cannot segregate saying due diligence is important for just legal and compliance. Due diligence is also important for business, because nobody wants to do business if your reputation is bad. So, for example, if Surabhi has a bad reputation, I'm sure, Ahmed, your firm, your company will not be keen to work with us. So I think it's become a part of, yeah, exactly. So I know I have segued a lot from what my initial gift was, but it's going to be seen holistically, using contractual, whether it's proactive, reactive contracts, whether it's your processes, standardization, modular, keeping it in module, whether we need HR, accountability, all these things together have to run in parallel, and you have to have an internal buy-in as well as external buy-in. When I say external buy-in, it means your vendor should also understand, or your distributor needs to understand what is the relevance of due diligence. And today, distributors and vendors are very smart, Ahmed. They know that if they don't cooperate in due diligence, it is not possible for any company to proceed further. And also what I've seen the trend is, earlier I had seen that due diligence was only getting done for private limited companies, LLCs, or companies that were not public listed, small scale companies. But today, I've seen that due diligence are also getting conducted for, as big a company as $1 billion or multi-billion dollar companies. So it's not anymore just because I don't know you, I will do a due diligence. Even if I know you, I will still do a due diligence. So that's on that. Again, I know I segued quite a bit from what was the initial questions, but these were some thoughts that I wanted to present.
Thank you, Saloni. Thank you very much. Halil, can we go back to you? How do we make due diligence actionable right through the end? If, in your opinion, what are the key steps for effective monitoring and offboarding that most organizations often missed?
Of course. I mean, once again, answering this question at the end is, I don't have anything very wonderful to say on top of what my colleagues have said, but I wanted to stress one point. I mean, in my experience with working with international companies, we don't lose more money on business, but we can lose a lot of money on non-compliance and a bad termination. Because we onboarded the wrong distributor, we partnered with the wrong people. Decoupling from those sticky situations lose us so much time and manpower and money, is that I think this is a point that needs to be raised when it's not very easy to get a buy-in with the management, which is sometimes something that is raised. I'm also hearing it, in between the lines. How do we show that due diligence is important, is good? Are we going to lose business? Let me assure you, losing bad business from the beginning is much more profitable for your company, and not even in the long run. It's going to come up very quickly, and then entanglement, because your reputation of the company will be also dragged along the road, because they will be representing your products, your services, and it's going to be a nightmare. I mean, those who haven't gone through that kind of public scrutiny or big important, let's say, audits may not have seen how bad it can get, but I'm assuring you it can get very bad. And you might find yourself in a position where nobody can work. Whole subsidiaries get shut down if they go through an FCPA investigation. All the management is suspended. The legal teams come in. Only the lawyers make money out of it. External lawyers, not the internal in-house teams. So having that due diligence and the amount of risk that it can prevent the company from taking is enormous. And unfortunately, sometimes unless the bad thing happens, nobody really realizes how bad it can get, but it will. And there are plenty of examples of, go to the FCPA's website, you can see that at least the amount of money that they are, that the companies need to pay out of bad practices. And I can assure you there's at least that much paid on external counsel and administration, on top of that subsidiary or those subsidiaries stopping doing business for at least 6 months up to 1 year, because the organization is paralyzed with everyone coming in and auditing this and that. So, I mean, there's really, the amount of damage it can do to you and to your company is really immense. Going back to the original question, I mean, once again, I don't have a very clever new thing to add. Really, having audit rights of the principal or a third party, so that we can monitor the relationship going on, or having disclosure requirements, as Yasmeen has pointed out. If they go through something, they need to report back, and of course having clearly defined termination clauses for non-compliance. Not necessarily not hitting their targets. We can have that discussion all over the place for months and months, but non-compliance being a quick termination right for the principal is, from our perspective, the three things that you really have to have to wrap up the due diligence process, so that you have at least the correct wording in your agreements.
Thank you. Yasmeen, I'm back to you from this point of view, how to make the due diligence actionable right through the end, till the end. How do you ensure consistency in documentation for auditability, for instance, for regularity, compliance?
how to make the due diligence actionable. Yeah, so first you need to, I will speak from my experience because I've built so many due diligence platforms. So what I can say that you need to have a solid screening system that is covering your part of the world, because not all screening systems are covering per se Middle Eastern, African companies. They only focus on the European ones per se. So there are different types of screening systems. You need to have a strong tone at the top when it comes to the due diligence in order to get the business cooperating with you, and to always seek your advice to identify what is considered high risk, what is considered low or medium. And this specification that you do, it's according, again, to the risks of your sector and to the risk appetite of your management in your company. So this is not only one factor. And it's not the same for all companies. It's going to be definitely different. And you need to have, with this system, you need to have a good traceability in the system when it comes to the due diligence. Like, it's not like you did the due diligence for this customer or the business partner once and that's it. So you need to have an expiry date. Like for some companies, they do it on an annual basis. If it's a high risk, they need to renew the due diligence for the same business partners just to make sure that we are on the right track. If they are like medium to low risks, we can have it every 2 or 3 years. And this is all should be stated in your internal policies when it comes to the third-party management. What else? You need to provide training to the third parties. Like, this is something that I've been doing for so many years now, that your third parties are speaking on your behalf and their name is connected to yours. And this is a reputational risk on its own. So if they are not on the same page with you when it comes to compliance and when it comes to integrity, then you're not doing it right. So you have to provide proper training, not as extensive as you do inside your organization, like internally for your employees. However, you need to set a clear line with them that we are on the same page when it comes to compliance, when it comes to integrity, when it comes to onboarding of subcontractors. So I provide gifts and entertainment training, anti-corruption and bribery, antitrust, anti-money laundering, and code of conduct. And they need to acknowledge our code of conduct right after, just to make sure that we have covered all the possible risks that we can mitigate. If anything pops after this, then it's going to be taken on a case-by-case basis.
Ahmed,
I'm ready, but yes, okay, go on, please, Ghassan. Because I wanted to add something. Only one thing, Ghassan, that I bet that Yasmeen fought a lot with her CFO and CEO to get the cost for doing all this, even training third party. So this is incredible. I would like to have something. I would like to have a discuss with you about how did you convince your
I did it internally, so it's in our internal system. So we're relying so much on our internal team.
This is a very good point. Depend on maturity, of course, of the management. The maturity of the management will support all this. They will understand that it's much more cost effective if you start to comply now than to end up with a lot of sanctions, penalties, and everything, and reputation risks. So it's a wonderful job. Ghassan, back to you. Thank you.
I just wanted to jump on what Yasmeen said, and I mean, to answer your question, I think the best way to convince management is through a bad case. like for instance, I don't know, a bad debtor whose license was expired when we saw the file, right? Or the contract was never renewed, or etc. So those, like, really, unfortunately, bad examples really educate management on having a proactive approach. And to Yasmeen's point on expiry of assessments of supply, that's really important. So we had, an internal operation risk assessment. And then one of the main thing that the consultant that we brought from outside focused on is really the timelines to rectify and when we're going to review this operational assessment again. And it was plugged in everyone's calendar, because one thing is, yes, shiny assessments that are lost in the drawers of any companies, and they're outdated. But it's very important to keep on this kind of track, review of policies every year, quarterly review of, I don't know, action points. And in companies increasingly, Ahmed, and in CAFU, I was wearing the hat of General Counsel and Chief of Staff. So on the Chief of Staff was really the implementation of those projects. And one thing is to have policies, another thing is to implement them in the company. And you need to have someone on board. His focus 24/7 is to implement and make sure everyone is compliant with the policies that you enact.
Totally with you, Ghassan. However, I would use the bad case, as you said, the most important element to convince the management would be the last thing to convince. I would start first to speak their language. I mean by their language, not English or Hindi or Arabic. I mean the business language, to convince them through use the same terms and terminologies that they are using, how it is cost effective, how it would be the ROI, because the first question, why should I pay this and what will I get and when? So this is actually a very important thing and very essential to be a successful in-house lawyer, is to get used to this language more than the legal language. I filed this, I did that, I added contractual obligations, I made this. They cannot understand what you're saying. And of course, if a bad case happened, would make us, of course, the blamed one. The legal will be always blamed, it will be a reactive action, actually, which I do recommend for us, for the legal sector, to be proactive more than reactive. And good luck with all managements, and get the money needed for these new projects that we are doing.
Actually, Ahmed, to touch point on Ghassan's point here, with regards to the management, you have to wear so many hats in order to convince them. So if you are convincing the CEO alone, this is not the thing that you should be doing. You should be convincing the whole team, like the whole executive team, and you have to wear so many hats and know the key points, as Ahmed was saying here, that you need to know how to get the information to their heads. So it's not always like you need to scare them with the case, but you need to show them the good side as well from having the system that you are offering them. So this is from my experience, because I had to deal with lots of managements from different backgrounds. So I had to wear so many hats at the same meeting to convince him and to convince her and to convince everyone in the meeting. So I had to speak their language, as Ahmed said, and they got convinced at the end.
Even sometimes you have to convince your own team.
Yes, it's part of your legal skills, the persuasive skills that you need to use at this stage.
So, ladies and gentlemen, as we wrap up this incredibly insightful 2 hours, we have half an hour for us to have questions from our esteemed audience. I want to bring it all home for our audience also. Let's go around and the room, and one last time, in one sentence, I'd like each of you to share the single most actionable takeaway you want our audience to walk away with today regarding due diligence in high-risk regions. Saloni.
I think for me, the biggest thing is risk analysis. Be smart, not perfect. So that's what I'll say about the entire due diligence, whether it's initial, completion, monitoring, and many other aspects.
Thank you, Saloni. Surabhi. We are pronouncing it correct. Surabhi.
That's right. That's right. You're amongst the few who've said it correct. So I think I would like to kind of, I think one of the points made in the chats was that reputational damage is not curable. So I think drawing from that, I think it's very important that your contractual framework is drafted such that it's not only just kind of solving for issues after it's happened, but also kind of preventing the occurrence of a damage. So that's what I would say should be the key takeaway, that your contract should solve for preventing the damage rather than just looking at, okay, if something goes wrong, then how do we get out of it?
Perfect. Yasmeen?
I cannot stress more on awareness when it comes to the risks. So awareness is key. And this awareness goes to your employees, to your management, and to your third parties.
Thank you, Yasmeen. Nagy?
Okay.
Ahmed, Nagy?
Yeah, thank you. Well, if I would look into it in one sentence, it would be more of enhanced monitoring and due diligence while having the proper infrastructure and a framework would definitely result a better management of the overall aspects.
Great, thank you. Ghassan? By the way, the order is not only by alphabetically, ladies first and then alphabetically. That's it. So
that's always. It's
Mohammad Noor, this is your problem. Your name is Mohammad, the last name. Yes, Ghassan.
I would say in enforcement, I make sure that you have enforcement mechanisms within your contracts, within your internal policies, because your policies are as good as, to the extent that they can be enforced. So flashy policies without any proper execution will not hold anyone accountable. So make sure that you have enforcement mechanisms in place. Yeah.
Good one, Ghassan. Thank you. Halil?
Well, when it comes to compliance matters and due diligence, structure is crucial when the disaster strikes. So it's a very front-loaded process mostly. So hope for the best, but prepare for the worst is the motto we live by.
Thank you, Halil. Last but not least, Mohammad.
Thank you. I think I'll leave the AI space. I just want the audience as well as panelists to leverage technology again. It's a huge win, basically, to have a governed technology ecosystem in the organization, which can help you, get mundane tasks or operations automated at the back end when you can focus more on quality deliverables as well as investigations and so on. So leverage technology would be my yet to give over.
Thank you very much. Now we have time for questions, so I'm going to go to the chat box and address the question that was raised from Adarsh. Legal and compliance have to cater the need of business, then only it can be effectively useful to business. So at the stage of framework, we have to focus on for the next 10 to 15 years. I think this is a comment more than a question, and I do appreciate that. It's really right. Anyone would like to have to comment on this? Sartak, since due diligence forms such an integral part in today's business, what sort of problems do in-house counsels face while convincing the management to prioritize? It looks like we have all the same problem. Diligence sometimes even at the expense of shareholder value or profitability. I think it was answered through the session. If someone would like to have it in points 1, 2, 3 steps.
I
So
think
can you
since
repeat the
Yasmeen
question
already,
again?
Yeah, but, but in general, first of all, you have to speak the same language. You have to learn how to speak the same language. So as Yasmeen said, and this is not a single language. This is different languages. So when you speak to the CFO, you have to know the financial terms that will help you convince him. The commercial terms when you speak to your sales or a CEO, a success CEO, you have to combine all this language in one project that would show the business profit more than the business risks, which is more effective when you speak to them. Of course, you have to understand and learn all these languages first, and then try to move it to closely to their understanding. The main point is when you, from my point of view, and please everyone share your view, the main point is that you have to understand that you should not show, or you must show that you are not blocking the business. You have to show them that you are empowering the business, protecting more the business, and you understand the fine line between protection and otherwise. And the protection should be in a, let's say, in a reliable, moderated ratio, not so high as legal should be. As you work more and more in business, you understand that you can leave this point in order to protect the other point. You can go a little bit soft with this kind of action, so you can bring more business. And this by experience. If anyone would like to add something.
Yeah, I would echo what you're saying here of speaking their same language and also understand what matters the most to them. Like if you're speaking to the salesperson and you're telling them that you're going to add all of these processes for them in order to approve their requests to take this opportunity, take this business opportunity. How are you going to convince them that you're not a showstopper and you're just safeguarding the operations for them in order to gain the trust of other companies to work with you? So you need to picture it for them, which is the truth, that we are safeguarding the operations for them in order to have clean business or no business.
This is one of the skills that everyone should have as a lawyer, is to convince, how to speak to other parties. And this next one, Mr. Adarsh. Mr. Adarsh is joining, mashallah. Now the regulators are more focused on how the AML regulations are implemented in system, like more scrutinization of external AML audits, risk rating methods, AML policy and procedure. I like the comment, of course, which is true. Anyone would like to comment?
I think, Ahmed, that's a general comment. I think.
Yeah. Yes, Mohammad, please do.
No, I think that comment others looks like a general comment. He's just maybe addressing that the regulators are now mostly focused with regards to the regulations that's out there, of how their due diligence or how their audit works.
Again, from Adarsh, indemnity clauses also have to be integral part contact, not at all regarding the business risk, but also regarding the statutory risk. And again, I'm concur. And Adarsh also, in short, at the time of onboarding stage onwards, we have segregated the customer or connected party to low, medium, and high risk, which is practically right. So we can review the risk factors and red flags accordingly, as it is ongoing and continuous process. It will changes the flow of business.
I think Yasmeen did touch a point on this, Yasmeen. I think having the proper policy and process in place would not give you the room of short time. If there's an exercise of how vendors or suppliers or customers are being onboarded in general, it should go smoothly with the requirements as well as the trainings. So I think having a proper policy and process in place with vendor registration is, I think, the foundation if you don't want to have hiccups in the end.
Yeah, and also the proper mitigation measures that you should put, like, if they are high risk, that doesn't mean that you're not going to do business with them. They could be high risk because they are coming from a high risk country where investors or companies are not very keen to work there, but this is a good business opportunity for you. So how are you going to safeguard your operations while you work in this high risk country? So the mitigation measures comes after the assessment of the legal and compliance. And also in terms of the AML. So if you're not in a financial institution, you are not practically required to have an AML policy. So what you can do to protect your company is to put a mitigation measures when it comes to the payment terms. Every transactional operations there needs to be thoroughly assessed by you and by the financial controllers in your organization as well.
And maybe, Ahmed, I'll just add one more thing is that while compartmentalization, low, medium risk is important, but it is also important to have a review of what are our parameters of low, medium, high. It cannot be static. For example, if you have done that exercise, and it's a big exercise, if you have done that exercise 2 years back, obviously you can't do that exercise every month, but it also has to be, reviewed by the department responsible, whether it's a due diligence department, whether it's compliance department, whatever it may be the name or nomenclature. But it is also important because what may be a medium risk country can become a high risk country as well. So I think that taking a step back, whether it's due diligence, it's a compliance, it's a living organism. You have to kind of keep feeding it with whatever is there today, because whatever was there yesterday may not be applicable today. So I think that's, again, is very important. And I'll just add to what Yasmeen very brilliantly mentioned is the mitigation plan. But mitigation plan also has to be very actionable. Having a academic, and I think this is what Yasmeen had also mentioned, is having an academic actionable plan will not have any achievement of why we have done a due diligence. Sit with with the relevant stakeholders and see what is an actionable plan, what our perspective of things can be done may not be practically possible at the ground level, because our resources are very different from a distributor or vendor's resources, right? Then understanding, having a realistic timeline, all those things. Sometimes, you don't have an option but to go with the vendor, even if it's a high risk vendor. So all these things along with documentation is something that also has to be as relevant as just doing a due diligence. Due diligence is just the start. There is a complete cycle to it. And till the time that cycle is not run, I think even the initial due diligence will have limited relevance.
Actually, Adash wants to add it. Yes, please, Halil.
Sorry, Ahmed. I thought this was very valuable from Yasmeen and Saloni as to build on the narrative as to, whether due diligence plans are good or bad. How do we sell this idea? The due diligence is done to decide on what we're wearing to this party. Are we going to go with our t-shirt or are we going to put up our armor? What do we need? It's more about understanding the counterparty, and it comes with, the due diligence and the red flags doesn't necessarily mean that business is not going to be done. It's more about within which parameters we're going to do the business, what is going to be our exits, what is going to be our audit plan. Maybe, some partners we audit more regularly, others not necessarily. But we cannot know this, or then the policy can't be we audit everyone. Then that's, once again, you're using your resources in a bad way. It's really understanding where the risk lies. So the due diligence process from end to end is really understanding whom we're dealing with and whether we can deal with them with putting the safeguards that are available to us. Sometimes, yes, as Saloni has mentioned, it's a very risky partner. in a very risky area, but that's maybe the best one that we can find among the others. So we put down the plan and go forward. Everybody understands that there might be, difficulties, missteps along the way, but we know it in advance and try to put the legal guardrails up accordingly. So this, I think, has to seep in our narrative as to why the due diligence plans are important, and when we're trying to sell the idea to business teams and management when necessary.
And I think what we said in general doesn't only apply for AML, from the AML aspect, also for all other aspects, all other risks that should be looked at with the same way. Where, when, what, who. These are very important questions in order to empower the business, not to block it. We have another one from Sartak. Sartak says, I'd like to ask whether top management have been more receptive to external advice for due diligence from law firms, and does that take off some load from an in-house counsel's plate while also ensuring external validation of their strategies?
I think, Ahmed, it's such a sensitive topic because we have external counsels also here. But
no, it's actually it's okay, because it's always, of course, you have to go to a law firm for let's say the base, the greater frame.
Yes.
But when it comes to internal practice, internal action, that it is day-to-day business, of course, the internal in-house would have a lot to do, following up with, discussing with other departments. Even when you start to ask for law firm external law firm support, you should start this internally first by asking all the business units the right questions, so the law firm can or be able to understand the industry and do the framework. Please, Saloni.
And Ahmed, I think also the role of in-house counsel and compliance officers have changed drastically in the last 10 years. We are not paper pushers anymore, which would have been, I think, 2 decades or 3 decades back. Again, I'm not talking about people who work in-house counsel 20 years back had a lesser role, but the kind of evolvement, empowerment that legal and compliance has today may have been a little varied going back to, certain number of decades. So I think it's not correct to say that one has more credibility than the other, that in-house counsel have more credibility than the law firm, or vice versa. I think it's very subject sensitive. Only thing I do want to mention is, yes, as an in-house counsel, you have much more ear of your CEO, CFO, or your management than external counsel, because you're working with them on a daily basis. So there is a little more trust. There is a little more, speaking the language kind of advantage that we have. So I think, again, it's nothing to do with credibility or who is better than the other. Yes, of course, if you're unsure, you do bounce ideas with external counsel. Sometimes they do it pro bono, sometimes they do it as, with the paid fees. It's all dependent on what matter you're dealing with and what is the intensity, how technical it is. If you're not very confident about data privacy, of course, you will go to external counsel. But if it is an internal matter, then you will try to resolve this internally. Another point I'd like to say is, we are speaking so much about law, statute. We should also consider that due diligence compliance is not really only limited to statutes. It's also ethical consideration. It is also today governance. It is also a CSR. There is just too many flavors that have been added beyond statutory requirement or doing just that bare minimum. So I think that is, again, I would like to point out, it's not the needle of, okay, have I complied with certain FCPA obligations or UK Bribery Act or whatever, but it is also sometimes, what is the perception, what is our internal, ethos, and so on and so forth.
If I may, Ahmed, I think as well, sometimes your best ally are internal allies, be it the board of directors, be it the investors, other stakeholders, right? And the fact that you are, some companies at least, that really want to position themselves on the transparency level, they would issue ESG report which mandates certain practices to be in-house, right? So you don't have to always have the recourse of external counsel that would push your agenda, but it can be really internal or driven by the dynamic of the company and the growth of the company, where they want to be positioned on the international spectrum, on the expansion spectrum, right? So and this is your empowerment. You don't need external people to empower you as such. Yeah.
Ahmed, if I can maybe just add from a, let's say, a law firm perspective.
Law firm, yes.
Yes. We're seeing, to answer the question, I think that's been asked in terms of, are we seeing that the top management has become more receptive to taking external counsel advice for due diligence? I think definitely, yes, that's changed. I can see that. In the last, let's say, 3 to 4 years, the number of times we've got questions over, okay, we're entering into this contract and this is the counterparty. We need some form of a due diligence exercise done in terms of, let's say, legal compliance, ESG, etc. Right? That has just increased so much in the last few years. Like earlier, it was so much an internal exercise where, the company's in-house counsel or, the governance or board or whoever would do that. But now they're looking to, for various reasons, it could be, right? One, it could be for, you have a smaller team internally, so you want to kind of farm that out. It could be that. Two, it could be where, you think that, yes, let's get more specialist advice, for example, on these things where, you would see, like Saloni mentioned, data protection. You want to get more specialist advice. So we are seeing that change definitely. And again, it's also, you can see it in terms of when we quote our fees as well. Earlier, there would be so many discussions on, this is such a simple exercise. It's a DD. We just want you to look at ABC, nothing more. But now the organizations are realizing that it's not a simple tick box DD that, you tell us, oh, we've looked at the license, we've looked at this and we've looked at that. So therefore everything is great. So I think there is that recognition of what this entails and, it's not a simple exercise. So definitely I can see that there's a change internally, the top management level to recognize that, yes, this needs to be looked at and you may need specialist advice on certain aspects, because earlier you would always get like, oh, you just need to look at this. Why can't the in-house counsel just do it themselves? Those kind of aspects. So we are definitely seeing that change. But having said that, I don't think it necessarily takes, it takes it off from the in-house counsel's plate, because it's anyways, whatever the external counsels would do would still come back to an in-house counsel to see that this is what we are recommending, but now to implement it for your organization, it'll still have to be the in-house counsel to kind of take that role.
Thank you, Surabhi. I have one last question, and we are on short of time. So I appreciate from Minendra. I appreciate various perspectives discussed. Thank you, by panel. This is really good discussion. Thank you very much. Want to add that litigation risk has to be evaluated in first place. For example, litigation and legal notices in past 3 years that third party dealt has also to be looked into. Litigation risk can be first point to understand what kind of compliance culture this potential partner has been following in the past, which is something I do personally. I can mirror this, and I totally concur with that. And the second thing Minendra is saying, in case of cross-border transactions, how to evaluate another key point is geopolitical or economic risk at country level. This needs another session, Minendra, to speak about a full how to evaluate other. Yes, please. If something quickly, please.
For this point, with regards to the cross-border transaction and the geopolitical and economic risk, I would say that you can still do it internally just to check and assess the risks. So you can have a task force with your head of security, with your head of legal and compliance. So 3 of you together, you discuss the risks of the countries that you are working at from different perspectives. And you have the mitigation plan together. Like you add all the mitigation measures that you can add from different perspectives that is actionable and can be implemented in such situations for your business type. And you start discussing it with the management. This is how you navigate this a bit. With regards to your first point for the litigation risks, yes, you are right. The litigation risks is a factor that we have to have in our due diligences. And this is where our friends from the external law firms comes, because we ask for their advice with regards to the litigation risks as well. It's part of any sound due diligence. You need to look into the litigation risks as well.
Thank you, Yasmeen. Thank you very much. Thank you all, my fellows, distinguished panelists, and to all our esteemed audience. Thank you very much. Those are all extremely valuable insights to end on. We have successfully covered the core of third-party risk management in the Middle East and Africa region. And we explored how to identify hidden risk by looking for country-specific red flags, how to build scalable frameworks by defining the key components and documenting processes, and finally, how to make due diligence truly actionable through essential contract clauses, technological monitoring, and effective onboarding plan. On behalf of my colleagues, fellows, panelists, and myself, Ahmed, Zaki, I want to offer a massive thank you to our expert panelists, Saloni, Surabhi, Yasmeen, Ahmed, Ghassan, Halil, and Mohammad, Noor. Your practical advice and candid discussions have made this a vital session. Thank you, GC360 and the event for sure to arrange or coordinate this wonderful and amazing event. And to our audience, thank you for your engagement. Today I do admire when the audience have engaged in this kind of discussion, and we hope you take these frameworks and best practices back to your organization with benefit for your organization, inshallah. Thank you very much, and have a great rest for the day.
Before we leave, I think, Ahmed, we just maybe want to thank Ahmed for moderating this through and throughout smoothly.
Yes, exactly.
Thank you. Thank you, Ahmed, for being part of the game, and we always invest in the best.
I am so lucky to have you with me in the same session. I learned a lot from you guys. Thank you very much.
Thank you.
Thank you to all our speakers and everyone who has joined us today. We truly appreciate the valuable insights shared, and I'm sure our audience has gained practical takeaways that they can apply within their organization. We look forward to seeing you all at our upcoming virtual events in the MEA region. And thank you, and have a wonderful day. Thank you to all our speakers and our audience as well.
Have a wonderful day. Thank you.
Thank you.
تحولوا من وكالة بس الأرباح على حسابهم